Good morning, colleagues. I'm just stepping in a bit. I just got information from the assistant to the chairperson of COCTA, Honorable Dodovu, that he's having a challenge with his gadget, and that he's trying to sort that out. And once he
Recording
is
in
able
progress.
to join the meeting, he will join the meeting. Our members, obviously, I just yeah, I'm not even sure. I'm not even sure how to proceed. But Moss, maybe just verify the information as the committee secretary with regard to the chairperson of the committee. Moss, are you on the phone?
Thank you, Chairperson. The chairperson has a problem with this gadget, and on the basis of that, it seems as if the chair might be struggling to log in. However, he has made plan B to use his daughter's mobile, but I'm not sure whether is he winning. I'm trying to make a follow-up with him, Chairperson. Thank you.
Okay, thanks. Our members, I just thought I should say that so that members shouldn't be on the platform and wonder why nothing is going on. But Moss, if you can just make that follow up and just we give you 2 minutes to do that, then our members, we can try and take the process forward. Moss?
Noted, Chairperson. Noted, Chairperson.
Thank you.
Recording stopped.
Honorable Sheikh. Honorable Sheikh, Chairperson.
Yes, Moss.
This is an update. I've just now spoken to the chairperson. Apparently, he has a serious gadget problem. He won't be able, and is requesting that you chair the meeting.
Okay, it's not up to me to chair the meeting. I think it's in terms of the rules, the committee needs to decide that. Okay.
Yes, Chairperson. Can I facilitate the chair with your permission?
Yes, please.
Honorable members, good morning. Members will recall that in the absence of the chairperson, in terms of the rules of NCOP, the committee members are allowed to elect an acting chairperson for the purpose of chairing this meeting. And if members agree, can we have a member who would move for the election of an acting chairperson for the purpose of this meeting? Then we will allow a seconder. Honorable members.
We just get clarity, Moss. In terms of the rules, must the acting chairperson be a member of parliament?
Yeah, Honorable President, thank you very much for the question. That acting member should be a member serving in this committee.
Recording in progress.
Probably a permanent delegate in the committee on our body.
I propose the name of Honorable Rikus Badenhorst.
Honorable members, the name of Honorable Badenhorst has been moved. Any seconder, or is there any further nomination?
Chairperson, good day to you. It's the Honourable Walton. I will second Records Badenhorst, thank you.
Statistician General and their delegated officials when they need to be authorized to perform the functions of this act. And furthermore, Chairperson, just to bring clarity, subsection 2 is a provision that brings in
Thank you.
the requirement to
Honourable
respect
members.
the right to privacy and dignity.
Honourable Moss.
Honourable members, my apology.
Moss.
Yes, honourable member.
Moss. Yes, it's Honourable Malika. I want to nominate Honourable Sheikh to be the acting chair for today.
Honourable members, I'm looking at the system. It seems as if the chairperson is in the meeting. I've seen his name. Can I just verify that before we proceed with this process of electing acting chairperson? Yes, I've seen the chairperson is in the meeting, honourable members. My apology.
Honourable Moss, Honourable Sheikh.
Honourable Sheikh.
Honourable Dido is on the platform, Moss.
Yeah.
Honourable Dido.
Yo. Yeah, they are talking. But I can't hear the volume. Very important meeting. Yo.
We can hear you and see you, Honorable Chair.
Yes, I'm struggling. I even had to go to the shop to try my best to log in. I don't know whether this is very, very much inconvenience, but I apologize, and everything has turned upside down for me. Are you allowing me to change the meantime, Honorable Sheikh, until I battle? And in case that I'm going to struggle, Honorable Sheikh will continue with the meeting.
Chairperson, you got us in the process of electing an acting chair, but you're back on the platform. So please, yeah, continue.
Can you hear me, Honorable Sheikh?
Yes, Chair, we can hear you loud and clear.
Yes, I'm saying that I'm battling, as you can all see, because this is a very important meeting of the committee, and then I'm going to do my level best because, as you know, it's elections and I'm in the bundles and everything collapsed over my head, and I heartily apologize as a result of that. And that being the case, as I apologize, let me take this opportunity to heartily welcome all of you in this meeting, members of Parliament, officials from the Department of Octa, officials from the Department from Parliament, and everybody else who's part of this important meeting. As I said, you are all welcomed. We are meeting here, and I'm going to request more of what to fly the agenda so that we proceed. I'm struggling even in terms of checking whether do we form a quorum and all members who are supposed to be part of this meeting are here. Honorable Sheikh, just help me there because I can't tamper with this computer. I will disrupt it. Are we forming a quorum? Are all the necessary members present in this meeting? I can't pick up the tab to see that.
Chairperson, I think Moss is not okay. Chairperson, maybe just to let you know that members who are on the platform, it's myself, Honorable Bartlett, yourself, Honorable Maleka, Honorable Smith,
Honorable Bartlett.
Ndongeni, Honorable Khadebe, Honorable Badenhorst, yes.
Oh, we are forming a quorum.
Yeah.
We are okay. We're forming a quorum. It's sufficient. Honorable members, that is the agenda before you. Most have we received any apologies?
Chair, in terms of our record, we haven't yet received any formal apology, Chairperson. Thank you.
No apologies. Let's proceed. Honorable members, as you are aware, we are having this meeting because we want to consider the response from the department in respect of the mandates that came from different provinces. And as you are aware, we battled in terms of securing the mandate from the Limpopo Legislature as well as the Eastern Cape Legislature. And I'm advised that we ultimately yesterday received the one from Eastern Cape, and last week we received the one from Limpopo, which means that all the provinces, the 9 provinces, have submitted their negotiating mandate here, and in a very, very haste situation, we had to request the department to develop the response on all the negotiating mandates that we have as such, and I'm going to invite the department to respond to all the negotiating mandates from different provinces, and that we proceed as such in that sense. Dr. Naidu, I hope. Oh, I see some hands. Honorable Bartlett.
No, Chair, the legacy hand, it was before.
Legacy hand. I see the
we
hand
came
of
into the
Honorable
meeting,
Bayer
sorry.
Smith.
Good morning, honorable members, honorable chair. Thank you very much. Chairperson, just in terms of the agenda, I see on the agenda, the flow of the agenda is the department's response and then the tabling of the draft C list. So I am asking again, when at which stage here, or where's the space on the agenda for us as members to vote on each one of the proposed amendment clauses? Because we are supposed to decide as a committee whether we accept a specific amendment on a clause or not, based on the negotiating mandates that we got from the provinces. So I don't see that, because we cannot just give it to the department to decide which clauses are included and which clauses are not included. The decision lies with us as representatives from our various provinces. So I don't see that on there, and I want clarity on that.
Yeah, I don't know where to get that the department is going to do the job on our behalf, Honorable Bayer Smith. Honorable Bayer Smith, I repeat again, it's just on the 11th hour before we retire, before the term ends. We have the negotiating mandates from the provinces, right? They were sent to us and they were sent to the department. The job of the department is to respond to the negotiating mandates, because the negotiating mandates encapsulates what provinces think about this bill, what proposals are they making, what amendments are they suggesting. Obviously, it follows that after the department has presented its responses, we are going to discuss, and in that sense, we are going to decide as this committee which one to include and which one to exclude based on the response of the department. I don't know what confusion is that, or what problem is that. Why? Because this is how the procedure is going to be followed. And based on that, the draft C list, it is going to be presented. We are going to be immediately after item number 3. I didn't move to item number 4. I said the department is going to table its responses to what the provincial legislatures are saying. That's how the procedure is. And then once we are done with that, I will open the floor. You will go province per province, critique anything that you want to critique in relation to what the response of the department would have been and what the provinces would have indicated in their submissions after they had conducted their public hearings. This is how this procedure is going to be followed. There is no confusion about this. We are just a month before the elections, and the term will end. Are you still raising your hand, Honorable Smith?
Yes, Honorable Chair, I just want some clarity. Thank you. You've cleared some of my question that we will be making decisions on that. I then want to ask that because the C list is a product of the decision that's made. So then we are preambling. What the
No, let's not go there, Honorable Smith. Let's not go there, please. Let's deal with item number 3.
I'm asking, Chair, can I finish my question? I think I've got a right as a member of this committee.
Yeah, you have a right, but that's
Chair,
a month before the elections.
Give me an
You are
opportunity.
wasting the time. And
No,
I
I'm
think
not
you want
wasting
to
time. I'm here to work like you are
I'm
here
not
to
going
work.
to allow that.
Okay,
I'm
Chair.
not going to allow that, Honorable Smith. I'm saying
So
we're at item number 3.
So you're refusing me to speak
No,
now?
I will never refuse you to speak.
Okay.
I have a right as the chairperson of the meeting to direct this meeting, and that's what I'm doing. You have all the right to speak, but speak to the issue that is on the table. Don't be irrelevant to the issue that is on the table. And as the chair of this committee, I'll stop you and say you are irrelevant. You are not talking to the issue as you are supposed to talk to. Stick to what is on the table. That's what I'm requesting you to do.
Jay, can I finish what I were busy saying, please? Thank you very much. So the matter that I'm raising is that there's already a C list presented before we had this discussion. So, and in no way in this agenda it indicates that we are going to make that decision, because the product of the decision made is then the C list that will then be voted on. Yes, that will be sent to the provinces.
Yes, that's correct.
Okay.
And that list will be tabled in this meeting.
Yes. So that's why I'm asking.
Okay, I'm happy that you now understand. Honorable Sheikh?
No, it's not me understanding.
No, thank you, Chairperson. I think you've provided us with the necessary direction on the matter. I'm not sure if you can hear me, Chair. But Chair, I think this is a process, and I think we don't box things within this process. From the very first day that we were presented with this piece of legislation, Chair, we engaged on it. And as and when provinces have been making inputs in terms of their negotiating mandates, these have been presented to the committee. And this process then culminates in the C list. The C list itself is not cast in stone, Chair. It's for discussion. And I think that you've clarified as well. And I suggest we move on with the meeting. Thank you very much.
Okay, thank you very much. This is how it's going to be. Let's stick to the agenda. We will cause that immediately, honorable members, that the response from the department is presented. The department will present what the provinces are saying and that what their responses are in respect of the proposals for amendment by the provinces. And once we're done with that, we're going to engage. And emanating from that process, we emerge with the draft, with the C list. And in terms of this agenda draft, we have all the right as members of parliament to reject it if we want to. And reject it and say we don't want it. We don't want what we see before us because it's not in line, if that is the case, not in line with what the provinces are saying. I beg that we follow the procedure as such. Over to you, Dr. Nadia Naidu. Take us through that, please.
Good morning. Good morning, Honorable Chair and all members of the committee and colleagues on the call. Chair, the presentation that I'm going to make, at least try and go through all of it. If I struggle in between, I do have flu. I will invite my colleague Wayne to continue with the presentation. The presentation, Chair and honorable members, will be structured thus. We will provide a brief background as to how we've arrived here, the legislatures that we've briefed and when, our responses to the negotiating mandates that we've received for all of the provinces, except for the Eastern Cape province. We are yet to receive that as the department. and then some recommendations at the end of the presentation. We also have attached or binded together all of the negotiating mandates that we've received, and shared that at the previous engagement or prior to the previous engagement that we had undertaken in March. Suffice to say, Chair, that it's been around 4 months now since the National Assembly had considered the report of the Portfolio Committee in November and then submitted it to the Select Committee or to the NCOP. We had undertaken a briefing to the Select Committee on the 7th of February, and on the same day, the NCOP had referred the bill to the provincial legislatures for further processing. And we had also then supported the provincial legislatures with briefings, technical support, and then also had come back to the Select Committee on the 8th of March, and then on the 19th of March, dealt with the issues relating to those negotiating mandates that we had received at that point in time. Limpopo at that stage had not submitted their negotiating mandates, as well as the Eastern Cape, but we have since received the one from Limpopo. These are the dates where we briefed the 8 provincial legislatures. And then starting with the responses of the department to the negotiating mandates received from each of the provinces. Wayne, maybe if you can just get ready to present from Mpumalanga onwards, okay? While I go through these parts of the inputs that we received and our responses. So the Northern Cape had made some general comments around communities being excluded, a specific reference to the Namakwa region, and we've indicated in our response that we note their comments, but their public participation, as we've indicated in previous engagements with the Select Committee and even in the Portfolio Committee, that we see public participation as being really enhanced in the bill that we have before us. It goes much, much deeper in terms of what we have in the present Demarcation Act that is that we have. The next province relates to the inputs received from the Northwest province. And it is indicated there, especially in relation to Clause 26. Clause 26 deals with the initiation of boundary determinations as well as redetermination. And it says that the clause is silent regarding criteria used for determination and redetermination of boundaries. Safe to say that it only outlines the dominant authority that the board has in making such determination. And it goes on to propose that the following section must be added in the legislation. We have considered that. We have not supported it, as we're of the view that the bill already encompasses and provides a very comprehensive list of factors, in fact, more than what the present legislation provides for, which it must take into consideration when determining and redetermining municipal boundaries. In relation to KwaZulu-Natal, there were quite a few suggestions that were made. 3 in number, I think. The first is that related to the appointment of board members and of committees. And it proposed that the publication of the names of the board members as well as the committee members as required in clauses 10 and 16 of the bill must also include their qualifications in the interest of promoting transparency. We've supported that, and we have proposed an amendment to the draft in terms of how that revision to the bill could look like. The second proposal that came from the province related to clause 10.8 in particular, and which relates to the appointment of board members. And it says that the manner of filling vacancies on the board must be reviewed, and rather than the minister simply making a recommendation to the president from the existing list of additional names, the legislature proposes that this should be subject to a time frame, as it is very open-ended and may exclude any other person who may be eligible. This is in view of the fact that the term of board members is 5 years with an option to renew for a further term, which may result in the list becoming outdated and excluding other eligible persons. And then the legislature goes on and proposes insertions or revisions to the legislation that we have. We have not supported that proposal because we're of the view that the bill already makes provision to for the minister to initiate the relevant appointment process if none of the additional names referred to is available to fill the vacancy. And this is to avoid delays in terms of restarting the appointment process, which includes advertisement, recruitment, and selection, which could take a very long time. So colleagues would know from the appointment process, as provided with the legislation, there is a long list that is provided to the president, 3 extra names than that number which is made at the establishment of a board. And revisiting that long list would circumvent a lot of the challenges related to, or the duration in terms of appointing board members. The third proposal that came from the KZN Provincial Legislature dealt with the establishment and the constitution of the Appeals Authority, and it proposes that a more comprehensive process be provided for in that specific clause for the appointment of the Appeals Authority, similar to the process in clause 10, which is required when establishing the board or filling a vacancy. We have not supported that, and we believe that there needs to be a clear identity in terms of the 2 authorities that are to be established. And the Appeals Authority is pretty much, in terms of the provisions we have in the legislation, the bill, aligned to the way in which other institutions of a similar nature, be it tribunals, appeals authorities, are established. In relation to the inputs received from the Gauteng province, there were quite a few proposals that were made. The first being in relation to clause 8.2 of the bill, and where it says that there should be an addition dealing specifically where the board must act independently at all times with unfettered discretion, but also to exercise independent judgment. We have not supported the proposal, and we believe that the provisions in clause 4 adequately caters for that, where the authority must be independent, impartial, and perform its functions without fear, favor, or prejudice. In relation to clause 16.3, and this deals specifically with the criteria and qualifications for co-opted members not being specified, but also a requirement that the qualifications that are extended to board members also be extended to members of committees. This specifically relates to the holding of political office. We've supported the provision or the proposal, and we have also then proposed a revision to that specific clause in terms of how it could look, so that rather than committees being resigned to just a specific section of the clause, of clause 9, and not being subjected to clause 9.2, we said that the entire clause 9 is applicable to members of committees when they are appointed. Clause 16.4 deals with the with committees again, and the proposal from the province was that to provide limitations on the number of members that can be co-opted, and we have not supported that. And we have said that we're of the view that this could be dealt with in terms of the board's rules of procedure, in terms of how they establish committees, the number of committees, as well as the number of members of committees. Clause 26, as I've indicated, deals with the initiation of boundary processes, and it is proposed that a key consideration must be given to the term of office of the board and the time frame for considering the redetermination of municipal boundaries to be 10 years. This may cause administrative challenges as two boards will consider redeterminations. We have noted that, but we also say that in terms of the present provisions that we have now included in the bill, much different from the way the board is, or the term of the board is provided for in the existing legislation, in that the board's term is now aligned to the term and not financial year. It is now aligned to the term of municipality. So a direct correlation between those two, where a single board now will be responsible for determining the outer boundaries of municipalities, but also the inner boundaries. Something, if you look at the status quo, the board that went out at the end of Feb had drawn the outer boundaries of municipalities. A new board was appointed with effect from the 1st of March, and that board that is there now will be responsible for the inner boundaries of municipalities. So in the future, that would not happen. The next input came from the Gauteng province, specifically in relation to clause 40. And it says that the appointment of the board is too restrictive because ordinary citizens are not given a chance to be a part of the board. An appointment of board members, there is a need for clarification of the convener of the board as the judge. We have not supported the proposal, and we say that the bill offers an equal opportunity for the appointment of the chairperson as well as other members of the appeals authority to represent a broad cross-section of the population of the country. However, given the nature of the work to be conducted, the appeals authority, such persons must have proven experience in demarcation issues and sufficient legal training and experience. The sixth proposal that came from the province dealt with with section 41 of the existing act, where it talks about the 3-year budgets, as well as the funding for the integration of administrative systems, but also the viability to be considered when merging municipalities. We've noted that, and in our response, we've indicated that the introduction of the 10-year cycle for the determination or redetermination of boundaries intends to limit the challenges associated with amalgamations. When it comes to the provision of funding for mergers, that is provided for in the national fiscus, as was done in the 2016 experience that we had with major redeterminations that have taken place across the country. And that specifically clause 24C of the bill compels the board when determining or redetermining municipal boundaries to take into account the financial viability and administrative capacity of the municipality to perform its functions. Clause 26 also deals a proposal in relation to that the municipal boundary redetermination. It is proposed that ward delimitations should be done after 10 years. We've noted it, we have not supported it because there is a specific reason as to why ward delimitation has to take place every 5 years. And that is mostly because if you do not examine the norm in municipalities, and the norm being the number of councillors divided by the number of wards in the municipality, the number of registered voters between municipalities may not differ by more than 15%, of course, in exceptional circumstances, which is provided for in the bill. But if we do not monitor that, and if the norm is more than what is allowed by law, then we could run into trouble legally, and therefore ward delimitation has to take place every 5 years. Around municipal capacity assessments, while the inclusion of capacity assessment is welcomed, as the province indicate, the bill does not go far enough in ensuring that capacity assessments are well defined. To this end, it is recommended that the board, the department, and provinces develop guidelines for conducting capacity assessments. We have noted that, and the bill does provide the minister with power to prescribe any regulations in relation to the act. A general comment, a comment on general, that's a provincial representation of provincial officers as opposed to a centralized national office was proposed, which should make it easier for municipalities, communities, and stakeholders to engage and interact with the authority. We've noted that, and we say that as a department, it is already catered for in clause 6 of the bill. The question, how will the bill affect the traditional royal house? And we say that it is already catered for in clause 27 of the bill. The bill already makes provision for consultation with traditional and Khoisan leaders at all levels. And the areas of traditional rural communities are also amongst the factors to be taken into consideration when determining and redetermining municipal boundaries. In fact, this is something also similar, as you will note later in the presentation, that was raised by the Limpopo province as well. Honorable Chair, with your permission, I'd like to hand over to my colleague Wayne to take us from the slide onwards. Thank you. Wayne?
Thank you, DRG Naidu. Good morning, Honorable Chairperson, Honorable members and officials, colleagues. Can I just confirm is my slide visible, DRG?
Yes, we can see it, Wayne. Thanks.
Thank you. Thanks, DRG, and good morning again. So I'll be going through the next remaining 3 provinces, starting off in Mpumalanga. The first comment they've made, Honorable Chair, is in relation to clause number 5. That talks about, okay, there's a couple of clauses. It's clause 5 on functions of the authority, clause 7 around composition of the board, clause 26 around the initiation of the determinations, and 27 around notification of intention to consider requests for the determination of municipal boundaries. The proposal made by the province is that the Mpumalanga House of the Traditional and Khoisan leaders propose that according to the provisional clauses 5, 7, 26, and 27, the composition of the people who must serve in authority should be people who understand the nature of the demographics in the areas in which they reside, especially in the rural areas. The response from the department, Honorable Chairperson, Honorable members, is that in our view, the suggestion or proposal is already catered for in clause number 7, clause 27 of the bill, where provision is made for consultation with traditional and Khoisan leaders at all levels. Additionally, we are saying that areas of traditional rural communities are also amongst the factors to be taken into account when determining or redetermining municipal boundaries. Second comment A proposal is in relation to clause 38 that talks to the issue of establishment of the appeals authority. The proposal from the province is that there should be a determination of time for the handling of each appeal case, and a member who lodges an appeal should be updated on a regular basis on developments on their case or appeal. And lastly, all the cases or appeals should be dealt with within a specified time frame. The department notes this comment, and we're saying that see section 43 of the bill, where this matter has been addressed. The next comment from Mpumalanga, Honorable Chair, Honorable Members, is in relation to clause number 10, that talks to the issue of appointment of board members. Suggestion from the province is that the process outlined in the appointment of the board in clause 10 does not leave much room for the appointment of independent members of the board. For a selection panel, say for appointment of the Concord judge and the chair of the Commission for Gender Equality, all the other members are laced with political connections. The department notes this comment, and the view is that a composition of the selection panel goes far beyond representation of only MPs. Another comment in relation to clause number 10 was that the process itself is initiated by the minister, who must at the end send names to the president, which must consist of 3 names more than the required number. The community indicated that more open and accountable process. The Parliament is the most suitable institution to conduct the selection process for the appointment of board members or the selection panel. The province proposed a more transparent or public process of nomination and the interview process to be followed. I think the department repeats the comment above, where we note the comment and we say that the composition of selection panel goes far beyond representation of only MPs. The next comment from Mpumalanga, Honorable Chair, is in relation to clause 22 around the finances of the authority. The comment is that the bill can also indicate by stating how the board will address the unique challenge of lack of resources, which often hampers the board from conducting its work efficiently. The department's response is that, in our view, this particular matter, Honorable Chair, is already catered for in clause 22 of the bill, where it says the authority will be funded by money appropriated annually by the Parliament to enable it to exercise its powers and perform its functions effectively, and it may also receive money from any other source through the National Revenue Fund. Then one general comment received from Mpumalanga, proposal or the comment is that the demarcation should do a thorough verification through consultation with the House of Traditional Leaders and the entire community. The comment we made, I think we made a comment also early on, is in our view, this proposal is already catered for in clause 27 of the bill, where the bill makes ample provision for consultation with traditional and quasi leaders at all levels, Honorable Chair. There seems to be a repetition, so I'm going to skip this slide. Chair, the next few comments or proposals is from the Free State Legislature. They also made a comment in clause 10 around the appointment of board members, where it says the bill must also designate a percentage of the board to be people living with disability. The department's response is that we note the comment and the selection panel to consider this. The selection panel to consider this as part of its decision-making procedure. Additional comments from the province and around clause number 10 is that the bill must direct that advertisements for the nominations must be made such that they also reach people who don't have access to mainstream media. The department notes this comment. We say accessible media platforms for publication of the bill are already used and catered for in the bill. A third comment on clause 10, it says the province suggests or proposes that the individuals to be appointed must be screened and vetted thoroughly to avoid people who misrepresent their qualifications. As a department, we support this particular proposal, and as a proposed insertion that has been made, or a proposal is made for an insertion to clause 10 between brackets 4, which will insert the text in black highlighted or bold highlighted. It says that after having complied with the vetting and screening process. And lastly, on this slide from Free State on clause 24, it says the proposal or the comment is that the determination of wards must take into account the geographic, economic, and social factors, amongst others. The department's comment is that we note this comment, and our view is that this particular suggestion or proposal is catered for already in clause 24. The province also made comments, Honorable Chair, on clause 38 around the establishment of the Appeals Authority, where the comment is that the Appeals Authority must be accessible in the context and their context thereof. As a department, we say we note this, and it's a matter that we will consider as part of the development of the regulations that will support the bill. On clause 33, around the delimitation of wards, the comment or suggestion is that the 10-year period for ward delimitation is proposed. We say we don't support this. I think the Legislature gave extensive explanation earlier on around why we don't support this as a department. Clause 35, around the criteria for delimitation of wards, the comment or proposal is that the authority must undertake physical verification before ward changes are made. As a department, we say we don't support this proposal. The bill requires that the board must delimit a municipality into wards, taking into account, amongst others, topography and physical characteristics. The authority is limited to conduct physical verification site visits to the affected authority. Also see clause 6, between brackets, subclause H. Another general comment from the Free State Province in relation, it says that the authority must have provincial officers and provincial representatives thereof. We say that this particular matter is already covered in clause 6 of the bill, Chairperson. Chair, the next few slides, which is quite a lot, speaks to the comments from the Western Cape. So just bear with me, it's a lot of slides. The first comment, Chairperson, is a general comment from the Western Cape, which the department notes, where it says that the bill maintains the long-standing proposal for a 10-year interval for municipal boundary redemarcation. This will assist to address the governance and financial challenges resulting from frequent changes. The bill addresses the impact of the lack of a presence of a provincial authority of the Independent Municipal Demarcation Authority. Alternatively, the bill provides for provincial commissioners and provincial staffing at least. Thirdly, the bill eases up the appeals load by providing for provincial appeals authorities. And this the province seems to be supporting as an approach. The bill provides for the creation of a transitional grant funding regime for the financial impact of the decisions that IMDA takes. So this seems to be supported. And then lastly, what the bill proposes on strengthening communication and consultation is sufficient and grounded in practical and meaningful interactions. So with this comments, Chair, we support it as a department. The first comment is where it's a bit more specific, is in clause 1 and definitions, and the suggestion is that we consider inserting a definition of what is meant by president. As a department, we supported a particular suggestion. We inserted definition after the definition of the term political office, where we define president to mean the head of state and the head of national executive as provided for section 83 between brackets A of the Constitution. Secondly, the province provided a comment on clause 7.2 around how the board is composed, where the comment is, whereas the clause provides for the composition of the board must broadly reflect the composition of the African society and represent a pool of knowledge concerning issues related to the demarcation. There should be a more emphasis placed on gender, and the emphasis here is on gender. And the department says it notes this particular comment, and we believe that the selection panel must consider that this is part of the decision-making procedure. Clause 8, where the province provided that with the perilous state of some of the SOEs, the governance challenges with regard to the fiduciary responsibility of the board should not be underestimated. The province recommend to include the following clause in clause 8 between brackets 2, and it made suggestions there. As a department, we say we don't support this particular proposal. The status of the authority is already provided for in clause 4, where it says the authority must be independent, impartial, and perform its functions without fear, favor, or prejudice. The last comment on this slide, Honorable Chairperson, is in relation to clause 9.2e around the qualification of the board, where it's recommended that clause 9(2)(e) should be amended to include persons that hold positions in a political party office. As a department, we say we don't support this, but that we don't support this particular proposal. And our view is that the bill already covers those positions with political influence, and political office is defined in the bill. So there should be a common understanding of the meaning of that particular term. Chair, on this slide, Chair, there's a comment made around clause number 10(1)(b), around appointment of board members, where the province's view is that the composition of selection panel presents potential political influence. It's recommended that we consider alternative process for boards, which could include a parliamentary selection process. As a department, we said we note this particular suggestion, but our view is that the composition of the selection panel, as provided for upfront in early responses, goes far beyond representation of only members of parliament. Clause 10(3), the province provides a comment that says that it's a concern that the selection panel may determine its own procedures. As a department, we say we note this. While the selection panel may determine its own procedure, such procedure must be fair and transparent as provided for in clause 10 between brackets 3. The next particular comment is on clause number 10(8)(a), around the appointment of board members, where the province says that it's a concern that a default position for filling vacancies on the board is to require the president to fill the vacancies from the additional names that were submitted to the president in terms of subsection 5. The province recommend that any vacancy on the board be re-advertised and that the process outlined in this section be followed. As a department, we say we don't support the suggestion because the bill already makes provision for the minister to initiate the appointment process if none of the additional names referred to is available to fill the vacancies, to avoid delays of restarting the whole process again, Honorable Chairperson. The clause seeks to ensure smooth and effortless filling of vacancies, given that the candidate is already qualified to be a member of the board, as he or she would have undergone a thorough interview process. Chair, the next comment, Chair, is in relation to clause number 11(4), around the term, office, etc. of the board members. The province's comment here is saying that the members of the board are appointed on a part-time basis, except for the chairperson, whose appointment may either be full-time or part-time. By virtue of clause 13(1) the chairperson is a member of the board, and therefore, in terms of the former part of the clause 4, he or she will be part-time. Hence, there's no need to repeat that the chairperson may be part-time. It's a more language issue, and as a department, we say that we note this, and we have asked the legal drafters to assist with reviewing this particular cosmetic defect in the text. Next comment, Chairperson, is on clause 16(2)(a), where the province says that it's a concern that there's no limitation on how many committees the board can appoint to assist with its performance of its functions. The province recommends an amendment to clause 16(2)(a), which states that to insert before established, for the word established, the following text: subject to budget and available resources. As a department, we say we don't support this. Our view is that this should be dealt with in terms of the board's rules of procedure in section number 15 of the bill, the current version of the bill. Next comment is around section 16(3)(c) of the bill, where the province is of the view that the criteria and qualifications for the cooperative members are not specified. The province recommended the cooperative members should fulfill the requirements set out in clause 9(1). As a department, we say we support this, and we have proposed some changes to the clause, and the legal drafters will support us, will help us with the particular amendments, Honorable Chairperson. Clause 16(4), the province comments that with no limits provided upfront for the co-option of members, would this not be open to creating a board within the board? The province recommends that we consider limitations in the number of members that can be co-opted. Again, we say we don't support this, as the view from us as a department is that this be dealt with in terms of the board's rules of procedure in clause 15 of the bill. Clause 19(3)(b), which is the clause talking to the CEO of the board, where the province comments that the clause refers to seconded. However, there is no reference to the legal authorization of such secondment. The Public Administration Management Act is an example. A definition can be incorporated under clause 1 of the bill. The department will say, we note this, and the conditions of employment of employees, including secondment, is broadly covered in clause 20 of the bill, Chairperson. Honorable Chair. Chair, the next comment from the Western Cape Province is on clause number 24, where it says that the factors set out in clause 24 are supported, but they may need more careful identification in elaboration. In this context, it must be considered whether the inclusion of bulk service provisions in clause 24, particularly water catchment and service areas. As a department, we don't support this. The view we provided here, Chairperson, is that the bill already encompasses a comprehensive list of factors to be considered when determining and redetermining municipal boundaries, as provided for in clauses 23 and 24 of the bill, Chairperson. Chair, the next comment from the Western Cape Province is on clause 25. The province comments that consideration should be given to the inclusion of more measurable indicators or factors. The term to describe the factors in determining the establishment of a single category municipality is too broad. Then they give examples why they say that. This formulation raises a number of questions, such as how does one qualify for this? What is recommended here is to use quantified factors. For example, those contained in a South African functional town topology work undertaken by the Council for Scientific Industrial Research, etc. As a department, we say we note this, and we will consider this for inclusion in the regulations, but also considering other initiatives, policy imperatives, such as the STI, STR, and IUDF. Chair, clause 26.1, the comments, the department provides a comment that says that although the proviso attached to the time frame is linked with the movement of more than one whole ward in the municipality, it is not clear how the movement of more than one ward, it's not clear how the 10 years were determined. The department, we say here, we note this, we note the comment and concern raised by the province. We say the introduction of the 10-year cycle, 2 terms for determination of major boundaries intends to limit the challenges that is linked with amalgamations. Also see the general comment above on the similar comments made earlier. Chair, clause 29.8, excuse me, around public consultation. The province says that at the public meeting for determination of municipal boundaries, there should be a provision for an interpreter to address the vernacular needs of the public in the region. This is a need that was identified in past MDB demarcation board, Municipal Demarcation Board consultation meetings with the public. We say we support this. The bill provides for the use of any other appropriate means of communication when conveying a message. Clause 32.4c, the province comments that, proposes to omit the following words after the word may. In exceptional cases, including those referred to Section 697 of the Municipal Structures Act. The department don't support the suggestion, where in our qualification for supporting this is saying that the minister may decide on a different or shorter period only on exceptional cases. Clause 36.1, the clause provides for public consultation in the delimitation of wards to be conducted by the authority. The province recommends that for purpose of clarifying the roles and in terms of mandate, that there are clear provisions that relates to costs linked with these public consultations. For example, venue hiring, interpreting services, and audio-visual equipment, and that the costs must be borne by the authority. There's a proposal from the province. As a department, we say we don't support this, as the board is a constitutional institution that makes use of available facilities and resources from other state institutions. Clause 38.2 is proposed that the current appointment process of the appeal authority is inadequate. At present, the minister is empowered to draw up a list of names to the president to appoint from in response to a public call for nominations. The province recommends that a more comprehensive appointment process is preferable. We say we note this, and this matter will be considered as part of the regulations. And then lastly, from the provincial government of Western Cape, the comment that says that in their view, it will not be possible to perform any functions or give any effect to the current Demarcation Act, as the intention of the bill is to repeal the entire Demarcation Act as contained in the schedule to the bill. Therefore, the province provides that or recommends that the transitional arrangements as they currently stand should be revised so as to make enforceable the current actions of the board when the bill takes effect. The department says we note this, and this will be discussed in detail with the legal drafters or advisors who support in this process. Chairperson, then lastly is the comments we received from Limpopo. They commented on clause number 7, where they are saying that the requirement of regional diversity relating to the composition of the board in the main act should be retained, in addition to the new requirement of reflection of the broad South African society as provided for in clause 7 to 8. As a department, we say that we don't support this particular suggestion. The proposal, in our view, may constrain the appointment process. It is a consideration of the selection panel when appointing the authority. And below, we are just giving an indication of the revisions we've made to the bill after consultation or engagements at a portfolio committee level, where the suggestion to change it to broadly reflect was made at that level. Chair, clause 10, where the province of Limpopo said that the comment they made was that members of the national and provincial houses designated by the chairperson must be included in the board as ex officio members instead of being part of a selection panel. As a department, we say we don't support this. We believe that the inclusion of members of the national and provincial houses will impede or compromise the authority status as provided for in clause 4, which states that the authority must be independent, impartial, and perform its functions without fear, favor, or prejudice. And the second last slide, Chairperson, clause 33, where provincial legislature from Limpopo provided a comment that says that the areas of jurisdiction of municipal councils must be taken into account when delimiting or demarcating wards to avoid overlap of wards into jurisdictions of traditional councils. The department's comment is that, in our view, this particular comment or proposal or concern is already catered for in clause 24 between brackets F, where the bill makes provision for consultation with traditional Khoisan leaders at all levels. Areas of traditional rural communities are also amongst the factors to be considered when determining municipal boundaries. And then lastly, the province commented that the phrase "any person" in clause 43(1) must be construed to include not only individuals, but a group of individuals or associations who can exercise right of appeal on behalf of an individual or group of individuals or associations. As a department, we supported this particular suggestion, and we propose an amendment to the current clause by the insertion of the bold text on the slide, which reads "any person or a group of persons" as a suggestion to respond to the Limpopo suggestion. Chair, those were the comments we received from the 8 provinces, as well as our responses as a department to the comments, Chair. We recommend that the committee notes the contents of the presentation and the responses to the negotiating mandates. And lastly, note that the IMDA bill has been translated into 2 official languages, namely isiZulu and isiNdebele. The Afrikaans version is still awaited, Chairperson. Thank you very much.
Thank you very much, both Wayne and Kevin, for providing us with the submissions from provinces as well as the responses from the department. As I indicated, honorable members, the normal procedure would be that, having listened to the submissions by the legislatures and the responses, we engage, consider every submission from the provinces clause by clause. But then there is a small problem here. And the problem pertains to the mistake that I made regarding the submission of negotiating mandates from all provinces. I saw a letter yesterday from the Eastern Cape. I was under the impression that it was their negotiating mandate. As I indicated, I traveled the villages and it's quite difficult to access the necessary information, all of it. Now, it wasn't a negotiating mandate. I made a mistake. Now, the situation is as follows. We have received the negotiating mandates from 8 provinces and not 9 provinces. The Eastern Cape has not submitted its negotiating mandate. And this presents a problem. If we don't handle it carefully, it may lead us and the NCOP into trouble. As matters stand, we don't have the negotiating mandate from Eastern Cape. If I may remind members of this committee, the 8-week cycle passed around March, around a month ago, and we were in that predicament that 2 provinces, namely Limpopo and the Eastern Cape, had not submitted their negotiating mandate, and that the process ensued to engage with the 2 provinces, including me approaching the chairperson of the NCOP, Honorable Masondo, requesting an extension. And in terms of Rule 219, sub Rule 3 of our rules, that extension was provided by the chairperson of the NCOP, which means that this process extended beyond the maximum 8-week period. But be that as it may, the Eastern Cape has not submitted its negotiating mandate. We need a proper legal advice in terms of what is it that we need to do. But more than that, we need the political management of this whole process so that at the end of the day, we do not open ourselves up to litigation. We do not create unnecessary problems. We ensure that the process that is followed is meaningful in respect of participation and in respect of the submission of provinces on their negotiating mandates, as well as their final mandates, having drawn up the C list in this particular respect. We are at that point. Now, as matters stand, we have received 8 negotiating mandates from provinces. Eastern Cape has not submitted its negotiating mandate. And in the letter that the chair sent to the Eastern Cape, he indicated, and Limpopo, of course, he indicated that he was giving the extension, and the letter didn't stipulate what happens in case that the extension or the province doesn't submit its negotiating mandate. We are at that particular point. Now, sitting here analyzing this whole situation, I think that we have 2 options. The one option is that we must proceed with this meeting, engage with the submissions from provinces, as well as the responses from the department, with a view of developing the table, the C list which draft has already been tabled. The difficulty with that is that this might be a futile exercise. What if we do not receive the negotiating mandate from the Eastern Cape? And what if the process that we follow, if we proceed without the Eastern Cape, is declared illegal? Because we know that lately in our country, everything is contested in the court of law. This committee, since we work here, there was never a legislation that was unlawful or illegal as such. We have tried our level best to be cautious, to receive the necessary advice to ensure that we follow the law to the letter. And if we proceed and we are rejected in that sense, it will be for the first time that happens. And I want to throw this to the committee to say, this is the situation. If we want to, we can proceed with the meeting under the circumstances, and the circumstances are that the Eastern Cape has not presented its negotiating mandate, or we can go and obtain further legal opinion about what needs to be done, and further receive some political management from the authorities within the LCOP and Parliament as a whole in terms of what needs to be done. And that once we are satisfied that there are no problems and we have cleared all the hurdles, we can then proceed. And that proceeding will include that the Eastern Cape will have to be given time to submit its negotiating mandate, and that this negotiating mandate must be sent to the department. The department must also submit its responses to the negotiating mandate of the Eastern Cape, and that we discuss the whole package. Because we may discuss now only to find out that whatever that the Eastern Cape presents at the end of the day changes the whole equation of what we are doing. I'm emphasizing this particular point because throughout this process and in relation to the case law, the judgment of the Concord that is already in place, public participation must be meaningful. Parliament has got an obligation to take into consideration what the public has submitted, what the provinces would have submitted. We can't take like that, and that we are obligated and compelled to consider all of that. Now, I'm presenting this proposal to you that if you want us to proceed under the circumstances, we can, in the interest of time, or we can do what I'm proposing that we must do. That one, we obtain legal opinion around what do we do, whether we can proceed at the exclusion of the Eastern Cape. Two, we need the political management report accordingly to the authorities within the LCOP, and based on that, we formulate a decision, a response and a decision in terms of what we need to do. I'm going to open up this to members so that I hear your comment based on what I've just presented to you. Wayne, if you can just remove your screen there, it will really help us, please. I'm opening the floor for discussion, inputs on the basis of what I've said from members of this committee. Start with you, Honorable Sheikh.
No, thank you very much, Chairperson. I want to agree with your proposal, but firstly, also just to say that, Chair, I think since the beginning, when we were presented with this piece of legislation, we emphasized the importance and urgency of this bill, especially in relation to the fact that as we're moving into this end of the 6th term of Parliament and the beginning of the 2nd term of Parliament, so we're coming to the end of our term, but also due to the fact that the local government elections, when they do take place, there needed to be sufficient time especially in terms of ensuring that this piece of legislation is in place. And we also discussed issues around some of the challenges that arise around redetermination of municipal boundaries. And we felt that this piece of legislation is pretty much important. And hence, I think many of the provinces tried their level best to try and deal with that. Chair, while you say that you need to get further advice on the matter, I would agree with that. But I would also say that we should at least in today's session further, based on the presentation that has been made, especially in terms of the 8 provinces that have made specific proposals on this piece of legislation, that we engage this presentation, Chair. While in the meantime, Chairperson, you would then try and sort the necessary advices, whether they legal, procedural, or political for that matter. And then obviously give us a report as well in our next meeting. So Chair, I'm proposing that we continue with this process. The department has given us, made inputs, especially with the comments that we've received. If we can perhaps engage these inputs, because this does involve the 8 provinces, while Chair, you go and do the necessary consultations and come back to the committee. Thanks, Chair.
Thank you, Honorable Sheikh. Any other input?
If I may,
Any other input?
Yeah, sorry, Chair, I'm not going to put my video on. It's on Baardhorst. If I may, I'm happy to engage in the presentation that we've now seen from the department on behalf of my province and make some comments. I'm just concerned that, like you said, should we proceed now without the Eastern Cape's mandate? Will this process be legal going forward, and will it not nullify what we're going to do now next in this meeting?
Are you done, Honorable?
I'm finished, Chair.
I missed
Thank
the
you.
last part of your submission on Baardhorst.
Chair, I'm just concerned that based on what you said, we are going to proceed now, and I'm happy to proceed with comments from my province on the departmental inputs. But are we, in the absence of the Eastern Cape's submission, are we not going to proceed now with something that's not legal, and then in that sense nullify what we are going to do next? So from the start we said there's a procedural issues here, and this what's happening now at the Eastern Cape speaks to that as well. In fact, the Western Cape also has a big procedural issue with regards to this process. But anyway, we'll be guided by what you decide, or the rest of the committee decide, Chair.
Look, it is so sad that an important piece of legislation like this one, we find ourselves in this situation because of one province. This is unprecedented. It has never happened. I never, in my 5 years in this BT and in this NCOP, encountered this kind of a situation. But we need a solution, that as it may. And I give Honorable Butler before Honorable another bite.
Yes, I know, Chair. I've raised my hand, but now you conclude on the matter. But the other thing is, we can, because of one province, and now we know it's very important, not going forward with this process. So, Chair, I just agree with you.
All right,
As
thank
much
you
as
very
we
much.
know we are 9 provinces, one province is still delaying us.
Okay. Honorable Sheikh?
Yeah, thank you very much, Chairperson. Chairperson, I think we are not at a stage where we're concluding a matter. We're not concluding issues with regard to this piece of legislation. In fact, we're busy processing legislation. So while the Chairperson further goes and seeks the necessary advice, Chairperson, My proposal was that we consider the presentation today, which is based on 8 provinces' comments. And the chairperson will then come back to us based on whatever advices he receives to then, we can then agree in terms of how we take processes forward. So the consideration of the department's presentation today, I mean, we're not concluding business on this piece of legislation. We're looking at what 8 provinces have said, the technical responses from the department in relation to those 8 provinces. And I don't see any problem with us engaging this process for now, Chair, while you seek the necessary advices, Chair. Thank you.
All right, thank you very much. Honorable Smith, and then I'll give the legal advisor.
Thank you, Honourable Chairperson. Honourable Chair, in this case, I agree with you on this matter, because I am concerned if we continue without Eastern Cape having a negotiating mandate and then later bringing the negotiating mandate in, because that gives them the power to negotiate on the matter, in fact. And if we engage now, what are we going to engage except for getting clarity questions? If that's the case, then it's fine. We can continue with that part. But in terms of discussing and making any decision on any clauses or amendments is going to be a problem. I am afraid if we continue and with the other 8 provinces and then bring the other province in at the end, then they are excluded at this process, because they have got a negotiating mandate, each province, to negotiate with other provinces on each aspect of the amendments. So I am concerned, and I agree with you that it be referred after we get the legal clarification. Thank you.
Okay. Now can we take the legal opinion?
Morning, Chairperson. I'm not sure if you can hear me. Can you hear me, Chair?
Yeah, I can hear you.
Yes, you confused me, Chair, when you said legal advisor, because I could see my colleague, Mr. Mbele, his hand was up, so I didn't want to jump the queue.
Oh, yes,
Yes, Chairperson, the fact of the matter is this, Chairperson, and with the greatest of respect, Chairperson, and of course, at the risk, Chairperson, of preaching to the converted. Chairperson, South Africa is a constitutional democracy that upholds representative and participatory democracy. The purpose of public participation and involvement in democratic processes is primarily to influence decision-making processes that affect the will of the people. Public participation is premised on the belief that those who are affected by a decision have the right to be involved in the decision-making process. Now, central to this, Chairperson, is the acknowledgement that institutions with decision-making powers must involve those who are likely to be affected by such decisions. Chairperson, you will recall that on the 9th of February, the Eastern Cape wrote a letter to Honorable Masondo, the chairperson of the NCOP. And in that letter, Chairperson, they made it clear that because they are seized with other bills, with other pieces of legislation, they would not be in a position to give us their mandate before the 31st of March. And in effect, Chairperson, in that letter, they then applied for an extension, Chairperson. That's the effect of it. They speak about a deferral. And of course, Chair, as you know, that on the 26th of March, the chairperson of the NCOP, Honorable Masondo, wrote to you, Chairperson, approving such a request, and approving it, Chair, in terms of Rule 2193 of the NCOP, as you have said, Chairperson. Now, Chairperson, this rule, of course, I'll read it. It's a very short rule, Chair, for the benefit of all the members. In the event that the substance of the bill requires more time than the 8-week period, the chairperson of the council may, on request by the chairperson of the relevant committee or speaker of a provincial legislature, extend the period. So, Chairperson, what we have in front of us, we have a letter, Chairperson, written by Chairperson Masondo, saying to the Eastern Cape that we are granting you your request for an extension. Now, Chair, I don't know from what authority would we be proceeding without them. I will not underscore, Chairperson, as we've done in the previous meeting, the importance of this bill. And those of us who've been around know what happened in Kutseng, in Mause, in Matatiela, and so on because of this. This, Chairperson, is legislation which deals with strategic issues. I would say, Chairperson, of national importance. And Chairperson, our courts, Chairperson, have been clear in terms of what needs to be done. And Chair, you will recall that recently in Mohale, relying on Doctors for Life, Chair, the Constitutional Court set out the factors to be considered when determining whether public participation was reasonable or not. And of course, Chairperson, it says this includes the nature and importance of the legislation and the intensity of its impact on the public are especially relevant. Reasonableness also requires that appropriate account be paid to practicalities such as time and expense, which relate to the efficiency of the lawmaking process. It goes beyond, so it says, yet the saving of money and time in itself does not justify inadequate opportunities for public involvement. And of course, Chair will agree with me that the Concord in Mohale said, if the NCOP is to rely on the provincial legislatures to facilitate public involvement, it must, it used the peremptory language, it must satisfy itself that the provincial legislatures hold public hearings that meet the constitutional standard. This requires the NCOP to be aware of the steps that the respective provincial legislatures took to facilitate public involvement. The provincial hearings are part of the NCOP process, and any shortcomings in the processes of the provincial legislatures fall to be attributed or imputed to the NCOP. Now, Chairperson, in conclusion, one of the issues we had to be confronted with when we were dealing with the Mohale case, and when I say which, Chairperson, I'm referring to Parliament, which is the National Assembly and NCOP, was the issue of there is no evidence that there is any pressure on Parliament to pass this legislation within any particular time frame. In other words, as in tomorrow or next week or next month. Nor does anybody assert that there is any deadline requiring urgent action. All I'm saying, Chairperson, is that when you look at this legislation, Chairperson, I even make an example, Chair, of the political party funding bill, Chair, where, for instance, Chair, the question would be, if, for instance, we give everybody adequate opportunity, as we know, the Western Cape has also complained that the kind of public participation process it has undertaken falls short of the constitutional standard. And I'm saying, Chairperson, if the court were to ask us, why the rush? Why are we rushing? Why are we locking out an entire province on an issue as important as this one? And I'm saying, Chairperson, who would be found wanted, Chairperson, because it's not like the sky is going to fall. And sorry, Chairperson, for that, with due respect. All I'm saying, Chairperson, is that currently and factually, the Eastern Cape has a letter granting it extension. And I do not know, Chairperson, on what basis would we be continuing without them. Chairperson, I won't take it any further than that. But it's for the committee, Chairperson, to decide, of course. But us, Chairperson, as legal services, we have reservations, Chairperson. We are not happy about the fact that the Eastern Cape, Chairperson, is being locked out of this particular process. Thank you very much.
So let me start there where you end. You're making a mistake. Nobody has locked out the Eastern Cape.
Yes, Chairperson.
They have locked out themselves out of this process. That is the provincial legislature of the Eastern Cape. Like all other provinces, we have afforded them the opportunity. They didn't comply with the deadlines that we stipulated. We gave them time by extending. Limpopo has come to the party, and the Eastern Cape has not. And I don't want us to ask this and that and that. We are here, and where are we? We are at a point where we have received the 8 negotiating mandates from provinces, the responses from the department, and 8 out of 9 has complied. We are left with the Eastern Cape. The question is whether do we proceed now or we proceed at a later date. And it will never be our intention whatsoever to lock out the Eastern Cape. They have locked themselves out, and we are in the process of unlocking that. And my view is that under the circumstances, what do we do? But I see 2 hands before I put together and summarize the discussions as they unfold. Honorable Sheikh, and followed by Honorable Badenhorst. Then I will summarize the discussion and put a firm proposal on the table about the way forward.
No, yeah, thanks, Jefferson. Maybe I'm jumping the gun because you're going to deal with the way forward. But I think legal did provide me with some additional clarity on the Eastern Cape. I can't help but agree with your comment that we're not looking at any province. We take public participation very seriously as a collective committee. We process many pieces of legislation. Indeed, Chair, I would propose that you still move forward and get the necessary procedural advice on this matter. And that perhaps my suggestion with regard to us engaging the report, Chairperson, I don't see any harm in that. But I mean, I propose perhaps let us not do that and let us maybe allow a little bit of time, to get a little bit of clarity on some of these aspects, and that in the next meeting we'll the matter further. Thanks, Chair.
Thank you. Honorable Badenhorst.
Honorable Chair, thank you very much. And I think my submission now is also based on what the legal submission was prior to you. We've got first of all, we've got case law. We've got Doctors for Life that's very clear and saying that the principal legislation can be declared invalid if there's a lack of public participation in the lawmaking process. That's that process that we are busy with at the moment. So we've got case law saying that it could be declared invalid if there's not proper public participation. In terms of our own rules, and our legal advisor has summarized those rules in the previous opinion they've already given us, where there's in Rule 219, and I'm going to specifically refer to 2193. In the event that the substance of the bill requires more time than the 8-week period, and that 8-week period is a minimum period, it's not a maximum period, it's a minimum period. The chairperson of the council may, at the request of the chairperson of the relevant committee, or, and it's my emphasis here, the speaker of a provisional legislature may extend that period. So my speaker of the Western Cape Provincial Legislature wrote a letter already on the 15th of February to the office of Honorable Masondu at the NCOP, explaining exactly the timeline, saying that they received, the bill is scheduled to take place on the 8th of March, and the final mandate was scheduled for the 22nd of March. The committee received a briefing on the bill on the 13th of February, in which already they raised their concerns regarding the stringent timelines provided for the submission of the negotiating and final mandates. Our committee resolved to write to stakeholders and make use of social media in the meantime to solicit public comments on the bill. However, to ensure proper public participation, the bill will need to have been advertised for at least 2 to 3 weeks before proceeding to public hearings. As the bill has direct impact on municipalities, and given the nature, scope, and possible impact of the bill, it will most likely require the committee to extend public hearings to at least 8 municipal districts of the Western Cape. Once the public hearings has taken place, it stands to reason that the committee will need sufficient time to collate all the submissions received during the public participation process. Current timelines suggested that by the Select Committee are too short for the Western Cape Provincial Parliament to facilitate adequate public involvement and consultation. Due to prior parliamentary commitments and the fact that the briefing of the NCOP Select Committee only took place on the 7th of February, the committee could only be briefed on the bill on the 13th of February. This letter that I'm referring to now, Honourable Chair, was written on the 15th of February. So the committee acted immediately.
Honourable Badenos,
Okay, I'm
why
concluding.
are you talking about?
I'm concluding because this letter
because
was
now you're
not,
talking about the Western Cape.
Yes, I'm concluding because
the
this letter
predicament that
was
we
not
have.
a letter
is
of
with
the
regard to
Eastern
Cape.
A letter of the Eastern Cape was mentioned, but no mention has been made of this letter of the Western Cape. So I want to put it on record that the Western Cape also asked for extension to the Honourable Masandu, and I don't know if there was a response or an extension granted. We don't know. The letter was written.
No, Honourable Badenhorst, let me try to guide the meeting. We are at a point where we are discussing the Eastern Cape. We are not discussing any other province. 8 provinces have submitted. We did receive the letter, and I said in this meeting a long time ago, we did receive, and you also mentioned it several times in our meetings, that the Western Cape had submitted its concerns about this whole process. And we've received that letter. But subsequent to that, the Western Cape submitted what they put on the table. And more than any other province, the submission from the Western Cape is more long, intense, and comprehensive than any other province. Now, the predicament that we have is not about the Western Cape, it's about the Eastern Cape. That is why I'm concerned now. You taking us back and raising the issues of the Western Cape that were brought to our attention, that we know. Particular things were by the church. At a point when this letter was written, it was for the Limpopo province and the Eastern Cape, because the Western Cape had duly submitted its negotiating mandate. That is why I'm concerned now. You are taking us back to that process. Now, with due respect, I want to urge all of you to say, we are at a point where we're facing this dilemma about the Eastern Cape. And all of you are saying it, and I agree with you, that public participation must be meaningful. We must not lock anyone outside this process. Everybody must participate. We have said that this legislation is extremely important because it will have profound implications in the local government elections. We have said that, and we have all agreed about that particular process. And if any challenges comes in respect of participation, let it be. Let us take it from there. We are at a point where we are discussing the Eastern Cape and what do we do. And as I understand, members are saying to us that let us not proceed. And I agree with that proposal. Let's not proceed.
Respond to you, please.
Sorry?
Can you give me an opportunity, once you finish your soliloquy, to respond to what you're saying, please?
Point of order, Chairperson, because
of the Western Cape. Now, I don't want you to respond on the issue of the Western Cape because the submission that you are making, it is irrelevant with due respect, because we've dealt with all the provinces. And even the letter that we have submitted.
Aspect.
No, honorable members.
No, Chair, also out of.
No. All of you, honorable members, I'm on the platform. Honorable Badenhorst, please, I request you. I'm on the platform and I'm addressing the pertinent issues in response to what you were doing. Basically, you are out of order because now you're bringing in the issues of the Western Cape. The Western Cape that is submitted, with all the concerns and the issues that the Western Cape raised in its letter. We have noted that. We know about it. They were brought to my attention. They were brought to the attention of the chairperson. And I will not allow you to raise the same issues that all of us know. I can't do that. This discussion is about what do we do in respect of the Eastern Cape that has not submitted. It is all about that. And any challenge in respect of what the provinces have done, the 8 provinces, be it. We are not at that particular point. If I give you a platform now, speak on the matter that is on the table, and the matter is, what do we do with the submission of the non-submission of the Eastern Cape? Not the Western Cape. Not the Western Cape. The Western Cape has submitted. We have their submission. They've given us proper suggestions. So I've listened to those, and we took more time in terms of the Western Cape. It means that whoever drafted, in respect of what the Western Cape has done an elaborate job to inform this committee and make suggestions about what needs to be done and how to improve this bill. We have listened to that. And we have not gone to the point where we deliberate and discuss the submissions and the response of the Western Cape and other provinces, as well as the responses from the department. Any person who speaks about that is out of order, and I'm not going to allow it. If you speak on the matter that is on the table with due respect. Please, I'll give you that platform.
What I want to do, I'm using the Western Cape as an example, but you're not giving me opportunity.
No, you're not using an example. You are reading what the Speaker of the Legislature of the Western Cape was doing. You were telling us what the work of the Western Cape is and what concerns they had, their strategies in terms of public participation. That's what you were doing. That was not an example. You're not using it as an example. You were
I was getting to my conclusion, but you didn't want to allow me to conclude.
Please.
Chair, we're heading down this exactly the same route at the moment as in the Mukhali judgment. So I'm not going to read the Mukhali judgment to you, but that's what this committee is now heading down the same route. I was trying to use the Western Cape, and in this case, the Eastern Cape as an example, where they're saying there wasn't enough time for meaningful, I'm emphasizing meaningful public participation. Yes, the Western Cape did submit, but under duress. And to submit something just to get it done, it doesn't say it was meaningful. Thank you, Chair.
Yeah, yes, let me just address that particular issue very quickly. That nobody will force any legislator to submit under duress. I will not. Nobody has put a gun on top of the Western Cape to submit whatever it has submitted. No, that will be unlawful and that will be unacceptable. And you should not do that. It's not the route that we must take, that because we say you must submit, we request you to submit, you will submit under duress. That will be unacceptable. I'm saying to you that we have 8 provinces. And if there is a problem, let it come, we'll deal with it. And it is not something strange. It is not something that is peculiar in respect of provinces citing their concerns about public participation. It has happened throughout. It has happened throughout that provinces say we think that we should have done better, we should have been given more time, we have done our level better, this is the work that we have done, and under the circumstances, this is a product that we are producing. This is not for the first time that this is happening. And I'm saying to you and saying to all the members, if we have a problem in respect of any other province, in respect of public participation, let it come, we'll deal with it when we cross that bridge. And we can use the Eastern Cape the dilemma to advance a particular view about other provinces. And I can tell you now, sitting here, that even my province have said that we didn't have more time. We would have loved to have more time because this law that is on the table impacts on local government. It's about municipal boundaries. It's about, demarcation and of municipal, but it's very much important. We needed more time, but we have done our best under the circumstances. And from the beginning, I said this legislation is very much important because it will have dire consequences to the local government elections. That's what I said. And I'm not pushing over the throat of everybody. I'm trying to do my job, understand the importance of facilitating this. And if we come to a point where we are not going to proceed, so be it. We are not going to proceed with it. We are not going to force it. We are not going to force it because that will be unconstitutional and it will be declared invalid. Now we are at the point of the Eastern Cape, and my proposal in respect of the discussions of this committee is that we are not deliberating, we are not taking discussions and making comments on the submissions that have been made. We are deferring this matter back on the note that we are going to receive the proper legal advice on what to do under the circumstances. That's the first thing. The second thing is that we are going to discuss the political management and political implications of this. And based on that, we will convene the meeting of this committee, and this committee will take it from there. But we are not going to force anything. We are not going to proceed if the circumstances don't allow us to proceed. We're not going to do that. And I'm the last person who's going to put this committee into trouble and do things because I want them to be done. No, I'm not going to do that. We are going to be rational. We are going to discuss properly. We are going to act really like members of parliament who are concerned about the matter that is on the table that we are dealing with. Nothing more, nothing less, and we are not going to be political about it. I thought perhaps that we must conclude that, but I see the hand of Honorable Smith. I'm very democratic to allow anybody to speak in that sense. Honorable Smith, before we conclude.
Thank you, Honorable Chair. I'm glad that you are very democratic. Chairperson, I am also glad that you yourself now admitted in your explanation now that even KwaZulu-Natal found that the time period did not allow for proper public participation, as it was a very squeezed time to get it through before the end of this term. So in terms of the process, and I think that is what was raised also by Honorable Badenhorst, is the matter that the total process, we as a committee have got a responsibility in terms of the law to ensure that we are satisfied that it is proper public participation and that the provinces do get enough time to do proper participation. And in this case, as you repeatedly said, that it's a very important piece of legislation, which puts an extra burden on top of us in terms of the rulings by the Constitutional Court before. That or by the court, that in fact we, if need be, we need to extend it even further. So the Western Cape, for example, the KwaZulu-Natal, Limpopo, Eastern Cape, to mention a few, all asked or raised the matter that the program is too squeezed, they are overloaded, they won't be able to do proper public participation, but a lot of them try to comply by doing submissions, but it doesn't, that submissions is not necessarily the product of proper public participation. And that is the issue that's raised, which undermines the validity of the process, which can be challenged in a court once again. And that is what we are raising, not the fact of this province or that, but that multiple provinces raised the same matter. So my submission is that the process is flawed, because even the Western Cape asked for extension. And that time when we discussed Limpopo and the Eastern Cape, let me finish, Chair. It was also mentioned that please engage the Western Cape, and you committed to also engage the Western Cape, which didn't happen. They haven't given an opportunity to go back and actually do proper public participation because they done it through social media. They didn't have an opportunity to go out, speak to the people, give them that space. Thank you very much.
I'm very generous to you, because now you are deliberating on the entire process, which you're not supposed to do. I repeat.
I've got the right to do that, Chair. I've got a responsibility, actually.
No, don't do that. Don't do that, Honorable Smith. Don't do that. I'm saying that we were deliberating about the Eastern Cape. I'm sure in the course of this discussion, if we proceed, there would be time when members of parliament express their concerns and their issues about the whole process. You will be allowed to do that. And I'm saying, I want to repeat this. This is not strange. This is not strange that obviously participation requires everybody to come in, and we must try as much as possible to be inclusive and to give provinces time. But there are rules that all of us must observe and must follow. And I can hear you using the word no longer meaningful, because nobody has said whatever that we did was not meaningful. And this is what the Concord has said. You may want to get an interpretation of what does it mean, does proper mean meaningful or what? I'm not there, but I'm saying to you that nobody has said that. Now, members, we conclude this meeting on that note, and I want to repeat it. The note is that we are not proceeding with the deliberations in respect of the negotiating mandates of provinces and then the responses of provinces of the department. And the reason is precisely because we have received 8 submission mandates at the Eastern Cape. Another second, we have given Eastern Cape an extension, which was sufficient. Other provinces did their best. They couldn't. We gave them more time. They couldn't. And we are in that dilemma. And that we need to get proper legal advice, and we need to get proper political management of this whole process. And based on that, after we've done that, we'll get we do with regard to the whole process. On that note, thank you very much for attending this meeting. And once more, I apologize. As you can see, in the bundus, in the villages, the situation is very, very terrible. I had to improvise to ensure that this meeting takes place, and I'm chairing this particular meeting as such. And whatever glitches, impediments, problems that we encounter, I really wish to apologize for that. On that note, thank you very much. The meeting is adjourned until we shortly, maybe this week or early next week, I'm not sure, we will convene a meeting to take this particular process forward. Thank you very much. The meeting is adjourned.
Thank you, Chair.
Chair.
Recording stopped.